Hi friends, good evening. Welcome to UPSC World Academy. This is Dr. Harinath Reddy, Director of the Institute. So today in this particular video, let us try to discuss the recent judgment of the Indian Supreme Court on the role of the governor in Tamil Nadu. And this equally applies to several other states where the opposition party is in power. Then this is an important judgment on a very important topic under the Indian Constitution. We will try to structure our discussion in the following subheadings. The first one, what is the background for this judgment? So what is the background for the judgment? The next one is, what are the constitutional provisions relating to the institution of governor in the context of giving assent to the bills passed by the state legislature? Then, what are the debates in the Constituent Assembly? So this is necessary to know the mind of the framers of the Indian Constitution. The next one, what is the judgment? What does the judgment include? Then there is one topic called constitutional silence. So along with the governor, there is one more topic, anti-defection law, where there is some silence in the constitution with respect to certain areas. What is that constitutional silence? What are the important judgments related to this particular judgment which were given from time to time? The next one, suggestions made by several commissions from time to time with respect to the assent to be given by the governor to the bills passed by the state legislature, especially when it comes to the time period. Then finally, suggestions. So what are the suggestions to address such problems in a better way? So if you take the background for the topic, we all know that India is a parliamentary democracy. So in a parliamentary democracy, there are two kinds of executive. That's what we say, dual executive. And in India, we have parliamentary democracy at two levels, at the union level and at the state level. At the union level, the president is the nominal executive. The Prime Minister and the Council of Ministers forms the real executive. Similarly, at the state level, the governor is the constitutional head and he forms the nominal executive, and the Chief Minister and the Council of Ministers forms the real executive. So in a parliamentary democracy, the real power is with the Prime Minister and Council of Ministers at the union level, and it is with the Chief Minister and the Council of Ministers at the state level. But at the union level, the entire administration is carried on in the name of the president. And at the state level, the entire administration is carried on in the name of the governor. So this is the position which is laid down in the Constitution of India. So the real power is with the Prime Minister and Council of Ministers and the Chief Minister and Council of Ministers. So given this context, let's see the various provisions in the Constitution of India which define the duties and powers of the governor relevant to the topic of the judgment of today. So if you take Article 159, Article 159 of the Indian Constitution speaks about the oath of office taken by the governor. So when the governor is administered oath, when he takes his office, he is administered oath, and as part of his oath he says that he will preserve, protect and defend the constitution and the laws of this country. So that's the oath which he takes, preserving, protecting and defending the constitution and the law, which means the president and the governor both are expected to protect and defend the constitution and the law. They should not do anything which undermines the constitution of India. Then if you take Article 163, Article 163 and similarly Article 74 at the union level, they say that at the union level, Article 74 says, the President shall act on the aid and advice of the Council of Ministers headed by Prime Minister. Similarly, at the state level, the Governor should act on the aid and advice of the Council of Ministers headed by Chief Minister, which means all the decisions are made by the Prime Minister and Council of Ministers in the name of the President, and then all the decisions at the state level are made by the Chief Minister and Council of Ministers in the name of the Governor. But Article 163 also speaks about discretionary powers of the governor. But When it comes to the discretionary powers of the governor, these discretionary powers are given to the governor to exercise these powers to preserve, protect and defend the constitution and the laws. And this discretionary power is not very wide and it is not absolute discretion. So this has to be exercised keeping in mind the letter and spirit of the constitution. It cannot be exercised arbitrarily and whimsically. Then we have one more article, Article 200. Article 200 speaks about the assent to be given by the governor to the bills passed by the state legislature. So a bill which is passed by the state legislature, whether it is unicameral or bicameral, it goes to the governor. The governor has four options. He can give assent to the bill, he can say no to the bill, he can send it back to the concerned state legislature for reconsideration, and he can also reserve it for the consideration of the president in certain cases. If the bill relates to the powers of the High Court, if the bill is repugnant, if it is in conflict with a central law, then the governor can exercise his discretion to reserve it for the president. That's what Article 200 says. And Article 200 also says a bill passed by the state legislature, if it goes to the governor, and if the governor sends it back to the state legislature for reconsideration, and after reconsideration of the bill is passed by the state legislature for the second time, then after it goes to the governor is bound to give his assent. He cannot keep it pending. He cannot refer it to the consideration of the president. So that's what Article 200 says. And Article 201 speaks about a bill which is reserved by the governor for the consideration of the president. Article 201 says the president has to give assent to the bill, or can withhold assent to the bill, or can send it back to the concerned state legislature for its reconsideration. If it is sent back to the state legislature for a reconsideration, the state legislature should reconsider it within 6 months. So these are the several constitutional provisions laid down in the Constitution of India with respect to the governor. Article 159, Article 163, Article 200, Article 201. Then let's take the debates in the Constituent Assembly. We all know that Constituent Assembly is the body which made the Constitution of India. If you want to know the minds of the framers of the Indian Constitution on any particular issue, we should go back to the debates in the Constituent Assembly and carefully look at the debates. So in the Constituent Assembly, some of the members of the Constituent Assembly, they have recommended electing the governor through popular vote. But Dr. Psir Ambedkar had rejected all these arguments, saying that at the state level, the governor is a nominal head, is a constitutional head. He doesn't enjoy the real powers. So it is not necessary to spend the time and waste money in his election. He also made it very clear that the discretionary powers given to the governor, they are narrow, they are not wide, and these discretionary powers cannot be exercised undermining the authority of the State Council of Ministers headed by Chief Ministers. So it is neither a negation of the Council of Ministers headed by Chief Minister, nor he can undermine and ignore the State Council of Ministers headed by Chief Minister. So by closely reading the Constituent Assembly debates, we can end up saying, according to the views of Dr. Psir Ambedkar, the governor is expected to be the constitutional and the titular head, the nominal head. He cannot go against the advice given by the State Council of Ministers headed by Chief Minister. Wherever he had a discretion, this discretionary power must be exercised with a sense of responsibility to preserve, protect and defend the Constitution of India. It cannot be exercised arbitrarily, whimsically, undermining the parliamentary democracy. So this is the reading of the Constituent Assembly debates. Then what is the judgment all about? So before we go to the judgment, let's see the background. We know that in the last 3 to 4 years, especially in states like Kerala, Tamil Nadu, Telangana, till recently, Telangana, Punjab, West Bengal. So these are the 5 states where the parties in opposition at the union level, they have captured power in all these states. For example, DMK in Tamil Nadu, Congress in Telangana, earlier TRS government, then Mamata Banerjee in West Bengal, Aam Aadmi Party in Punjab, Kerala, again opposition ruled governments. So the central government, by using the institution of governor, in all these 5 states, through the institution of governor, the bills passed by the state legislatures were not given assent to by the governor within a reasonable time frame. So if you see all these 5 states, in all these 5 states, especially in the state of Tamil Nadu, the governor is not acting on the bills passed by the state legislature. So he has sent back for the reconsideration of the state legislature. After reconsidering the state legislature, after it is passed by the state legislature, he is bound to give the assent. Even in such a situation, he is not giving the assent, sending it to the consideration of the president, which is not allowed. So this is what is going on in several states like Kerala, Punjab, West Bengal, Telangana and Tamil Nadu. So as the governor is merely the constitutional head of the state government, he cannot sit on the bills passed by the elected state legislature. So that is something which is undermining the Constitution of India, undermining parliamentary democracy in India. So this matter went before the Supreme Court, and what the governor of Tamil Nadu has done in the state of Tamil Nadu is, there are several bills, around 10 bills, passed by the state legislature, sent to the governor for the assent. The governor has taken very long time, and then he has sent it back for reconsideration. And after reconsideration, the bills were again sent to the governor. Even then, the governor has not given assent within reasonable time frame. There, the matter didn't stop. It was again referred to the president for the consideration. So this matter went before the Supreme Court, and the Supreme Court has very clearly said the following things. And remember, the judgment of the Supreme Court was given under Article 142. So there is one article, Article 142, which speaks about doing complete justice. The Supreme Court can pass any order for doing complete justice between the parties. So the recent judgment given by the Supreme Court on the governor of Tamil Nadu is given under Article 142 by invoking, remember, Article 142 gives an extraordinary power on the Indian Supreme Court to pass any order on any issue for doing complete justice. So this judgment with respect to the governor of Tamil Nadu was given by the Supreme Court under Article 142. So in this case, the Supreme Court has given an answer for the silence in the Constitution. What is the silence? So in Article 200 and in Article 201, it was not clearly laid down what is the time limit within which the governor has to give assent. What is the time limit within which the president has to give an assent. So here, the Supreme Court said, once a bill passed by the state legislature goes to the governor for the assent, for giving the assent, the governor should take a decision within 3 months. If he wants to send it to the state legislature back for reconsideration, he should do it within 3 months. Or if he wants to give the assent, he should do it within 3 months. Or if he wants to send it for the president for the consideration, again he should do it within 3 months. So this is the area where the Constitution is silent. Then a bill which is passed by the state legislature, going to the governor for the assent, coming back to the state legislature for reconsideration, it was reconsidered and again goes to the governor for the second time for the assent. Then this time the governor should give his assent within a month. He should not reserve it for the consideration of the president. So this was very clearly laid down by the Supreme Court. And again, this is a judgment. This is a judgment in this case. Then from time to time, there were several judgments in which the Supreme Court has considered this issue. For example, in 1962, Purushottaman Nambudiri versus State of Kerala. Purushottaman Nambudiri versus State of Kerala, 1962. So in this case, the Supreme Court upheld the discretion of the governor to delay giving assent to the bill for indefinite time. In other words, when the Constitution was silent on the issue of giving assent to the bills, This was upheld by the Supreme Court, which means the governor can take indefinite time giving assent to the bills. In my view, this was an erroneous judgment. This was a narrow interpretation of the Constitution of India. So the judges of the Supreme Court, they have given a very narrow interpretation. It doesn't reflect the letter and spirit of the Constitution. Then later on, in 1917, we have Raghukul Tilak versus State of Haryana. Raghukul Tilak versus State of Haryana, 1979. In this case, the Supreme Court said the governor is not an employee of the central government. The governor is a high constitutional authority with a lot of independence, which means he doesn't need to dance to the tunes of the central government. He can act independently. Again, there was one more important judgment, BP Singhal versus Union of India. In this case, the Supreme Court has clearly said that the governors can't be removed from office without valid grounds. Of course, there is something called the doctrine of pleasure. Under the doctrine of pleasure, the governor can be removed at any point of time by the president. But it being a constitutional office of high esteem, the Supreme Court in BP Singhal versus Union of India case very clearly said the governors can be removed only on valid grounds. Without giving valid reasons, if the governors are removed, then that will be subjected to judicial review. So that's one more judgment. Then again we have Shamsher Singh versus State of Punjab, 1974. In this case, the Supreme Court said at the state level, the governor is a nominal head. He is expected to act according to the advice of the State Council of Ministers headed by Chief Minister. Of course, there are certain areas where he had a discretion, but that is only an exception but not the norm. That's what the Supreme Court said in that case. Then in 2020 we had one more case, Kisham Meghachandra Singh versus Speaker Manipur Legislative Assembly. Kisham Meghachandra Singh versus Speaker Manipur Legislative Assembly. This is the case in which a judgment was given on anti-defection law. One important lacuna in the anti-defection law is, in the anti-defection law, there is no timeline, there is no time limit laid down for deciding the disqualification petitions. And as a result, the law has remained very ineffective. It is in this judgment, Kisham Meghachandra Singh versus Speaker Manipur Legislative Assembly, the Supreme Court has said that the Speaker must decide the disqualification petitions under the 10th schedule under the anti-defection law within 3 months. So here we see a similarity between the governor giving assent to the bills and the Speaker deciding the disqualification petitions. So these are the two areas where the Constitution is silent, and the highest court, that is the Supreme Court, has given a time limit of 3 months for the Speaker to decide on disqualification petitions, and again for the governor to give assent to the bills or send it for the reconsideration of the state legislature. He should do it within 3 months. Then we have one more case in 2023, State of Punjab versus Principal Secretary to the Governor of Punjab. Even in this case, the Supreme Court said the governor must decide within reasonable time frame with respect to the bills which are sent to him for the assent. If it is not done, it is unconstitutional and it undermines parliamentary democracy. In a parliamentary democracy, the real power is with the elected representatives, not with the governor. That's what the Supreme Court said. But in 2023 judgment, in this case, the Supreme Court has not given up any time frame for the governor giving assent to the bills. And finally, this matter was settled in this month, on April 8, 2025, in State of Tamil Nadu versus Governor of Tamil Nadu. In this case, the Supreme Court said that the governor has to decide within 3 months whether to give assent to the bill, whether to send it back for the state legislature for reconsideration, or even to reserve it for the consideration of the president. For all these three, the time limit is 3 months. Once a bill is reconsidered by the state legislature for the second time and sent to the governor for the second time, then the governor must decide giving assent within a month. So that's the judgment which was laid down. Then, what are the several commissions which were appointed from time to time, and what are their recommendations with respect to the time limit for the governor to give assent to the bills? So as I said, Article 201 and Article 200, they are silent and the time period within which the governor and the president has to give their assent. For example, if you take the National Commission to review the working of the Indian Constitution, the National Commission to review the working of the Indian Constitution has recommended a time period of 3 months for the president either to give the assent or to withhold the assent. Similarly, Sarkaria Commission also recommended that a time limit must be fixed for the governor in deciding the assent to the bills. Then we have Madan Mohan Kunchi Commission, which is the second commission on central-state relations. This commission said that the governor and the president must decide giving the assent or withholding assent within 6 months. And then finally we will end this topic by saying we have an important constitutional expert by name Faizan Mustafa. So this man, in one of the articles written in Indian Express, this man says one very big reason why the institution of governor has remained partial is lack of security of tenure. We all know that in India, Election Commission of India is independent, Supreme Court is independent, High Courts are independent, State Election Commission is independent, CAG is independent. And one single reason for the independence of all these bodies is security of tenure. All these functionaries which I told, they can be removed only by Parliament by absolute majority and a majority of 2/3 of the members present and voting. On the same lines, Madan Mohan Kunchi Commission has recommended that the governor must be given the security of tenure, which means though the governor could be appointed by the union government, the removal of the governor must not be in the hands of the union government. The removal of the governor must be in the hands of the state legislature. Like the President of India, who is impeached by Lok Sabha and Rajya Sabha by 2/3 of the total strength, the governor should also be removed by the legislative or some legislative council, wherever it is, by 2/3 of the members, by 2/3 of the total strength. So this one single reform will go a long way in making the institution of governor much more independent, transparent and objective. So that's it about the topic of the judgment of the Indian Supreme Court on the role of the governor in giving assent to the bills. Hope that this video will be very useful for you. We will come up with yet another video in the coming days on another important topic which has been in the news. Till then, thank you.